आज चाहिँ कस्तो छ नट ब्याड नि आज नमस्कार शुभ प्रभात लक्ष्मी प्रसाद खरेल हाम्रो कन्टिन्यू सिरिज हाम्रो जुन श्रृङ्खला कानुनको लेक्चरको श्रृङ्खला प्रवचनको श्रृङ्खला जारी छ र आज सायद हामी 1 महिना जति लगाएर संवैधानिक कानुनको चाहिँ सम्पूर्ण अध्यायहरू सम्पूर्ण च्याप्टरहरू त्यसभित्रका भागहरू हामीले लेक्चर गरिसकेछौँ र आजको लेक्चरको सिरिज चाहिँ तपाईको जुडिसियल रिभ्यू न्यायिक पुनरावलोकन PIL सार्वजनिक सरकार सम्बन्धी मुद्दा र न्यायिक सक्रियता जुडिसियल एक्टिभिजममा केन्द्रित रहनेछ र सुरुमा मैले चाहिँ न्यायिक पुनरावलोकन भनेको जुडिसियल रिभ्यू जसलाई अङ्ग्रेजीमा भनिन्छ जुडिसियल रिभ्यू व्हाइल जुडिसियल रिभ्यू मीन्स इट इज द पावर अफ थर्ड विङ जुडिसियल पावर टु इनभ्यालिडेट or to declare null and void any legislative and executive action. यो न्यायिक पुनरावलोकनलाई एउटा संविधानवादको एउटा एकदमै अत्यन्तै महत्त्वपूर्ण र अत्यन्तै आधारभूत तत्त्वको रूपमा लिइन्छ र न्यायिक पुनरावलोकनको सिद्धान्त धेरै जसो संवैधानिक सर्वोच्चता भएका मुलुकमा न्यायिक पुनरावलोकनको शक्ति रहेको हुन्छ न्यायपालिकामा र न्यायपालिका नै मैले अस्तिको लेक्चरमा भनिसकेको थिएँ एउटा ब्यालेन्सिङ व्हील र मोस्ट ट्रस्टेड अर्गन अफ द गभर्नमेन्ट सबैभन्दा विश्वासी अर्गन नै किनभने जुडिसियरीलाई मानिन्छ एक्जिक्युटिभले पनि गल्ती गर्न सक्छ एक्जिक्युटिभले गरेका गतिविधि र एक्जिक्युटिभका मतलब कार्यहरू पनि अनजस्ट पनि हुन सक्छन् अन्याय पनि हुन सक्छन् अनरिजनेबल पनि हुन सक्छन् र there may be the instances of arbitrary exercise of power उसले चाहिँ आफ्नो अधिकार चाहिँ स्वेच्छाचारी रूपमा प्रयोग गरेको पनि हुन सक्छ र विधायिकाले पनि अनजस्ट ल पनि स्थापना गरेको हुन सक्छ अनजस्ट ल जारी गरेको पनि हुन सक्छ तर जुडिसियरीले जहिले पनि जनताको हक अधिकार र कानुनको सर्वोच्चता संविधानको सर्वोच्चता र नागरिकको मौलिक अधिकार मानव अधिकारको रक्षाको लागि यसले अत्यन्तै सकारात्मक र अत्यन्तै क्रिएटिभ यसले अत्यन्तै रचनात्मक भूमिका निर्वाह गरेको हुन्छ भन्ने संविधानभित्र एउटा हामी कल्पना गर्न सक्छौँ एज आई सेड द्याट प्रिभियसली एन्ड फ्रिक्वेन्टली आई सेड द्याट जुडिसियल पावर इज पावर अफ इन्टरप्रिटेसन एन्ड जुडिसियल पावर इज पावर अफ इन्फोर्सिङ द फन्डामेन्टल राइट इट इज अल्सो पावर अफ giving the justice. It is also power of administering the justice or adjudicating the case. र न्यायिक पुनरावलोकन भनेको त्यस्तो शक्ति हो जहाँ न्यायपालिकाले कार्यकारिणीले र कार्यपालिका र व्यवस्थापिकाले गरेका ललेसनेसलाई कार्यलाई इनभ्यालिडेट त्यसलाई चाहिँ अवैध र त्यसलाई चाहिँ गैर कानुनी घोषणा गर्ने जुन संविधानमा न्यायपालिकालाई शक्ति दिएको हुन्छ त्यो शक्तिको प्रयोग गर्दै विधायिका र कार्यपालिकाका सम्पूर्ण गलत कार्य र गैर कानुनी कार्यलाई मतलब नल एन्ड भोइड शून्यकरण घोषणा गर्ने अवैध घोषणा गर्ने निष्प्रभावी घोषणा गर्ने अधिकारलाई चाहिँ एउटा जुडिसियल रिभ्यू भनिन्छ जुडिसियलले रिभ्यू गर्छ किन भन्दाखेरि हरेक संविधानमा यो चाहिँ तपाईको चाहिँ अन्तर्निहितै हुन्छ न्यायपालिकासँग उसले टेस्ट गर्ने काम गर्छ इट वुड टेस्ट द लिगालिटी इट वुड टेस्ट द लफुलनेस अफ बोथ एक्सन both action either that employed differently in different contexts the context of United States of America and context of United Kingdom this judicial review is employed differently because in United States you find the supremacy of constitution but whereas in United Kingdom you find the supremacy of the legislative action that's why this term judicial review has been explained differently means under the United States United Kingdom Constitution is the Constitution of United Kingdom is unwritten, it is uncodified, and it has been its constitution has been scattered in different laws, different acts, different precedents, and different custom and convention. That's why you cannot itself assert it. Constitution has not itself asserted judicial review in its constitution, but in United States this judicial review power has been asserted and clearly mentioned even in Constitution of Nepal. You find these instances under the Constitution of Kingdom of Nepal 2047 Article 88 1 and 2 where it was mentioned that Supreme Court can see the legality and constitutionality of any act made by legislature, as well as any action committed by any action performed by executive or administrative action administrative actions validity could have been checked, could have been experimented by judiciary. It is one of the inherent power. It is written that judicial power is an inherent power in constitution, and if there is judicial power vested frequently or vested with the intent to reserve and preserve the people's right, then the constitution is very balanced constitution. Even this constitution components are full of separation of power, and they are the full of constitutionalism. And judicial review, as I said frequently, that judicial review assures or ensures limited government, because it is a limited. Why it is limited? Because there is no usurpation of power by one branch of the government to another branch of the government, because there is a proper balance of power, because all branches, they work under their coordination, not subordination. That's why judicial review would check the lawlessness of both legislative and executive action there, because you say that only incorporating this function in constitution, you can say that all in practice these all are legal or constitutional, because in the course of ruling the nation, in the course of the time of administering the state mechanism, so many frauds may come under the purview of their day-to-day action, because you see public authority do day-to-day action somehow by its hairy intention or by malified intention, or without understanding the scope and jurisdiction of their work. So many unlawful tasks may be taken place. In that time, this judiciary, if it is filed in the court, if petition is filed, writ petition is filed in the court to invalidate this action, then it's an inherent power of the judiciary to check what it will check. It will check the both action of legislature and executive. And as I said that, for the first time in the history of the world, England, which claims that she is the mother of democracy, and England is a country who claims that they are best in everything, and England always respects rule of law, and England always proclaims that their law is supreme. Through the Magna Carta, it has been established a principle that traditional law is very supreme. But even if there is Parliament is supreme, but sometime judiciary in the first time as I said in 1610 or 1610 was the year where Supreme Court Chief Justice Edward Coke dare said that the law enacted by legislature, if it contradict with the natural justice or natural right or common law, this legislative action shall be null and void. In the same way, you see, there is one of the instances of Chief Justice Marshall in the case of Marbury versus Medicine, and another time it was like maybe it was Warren Court. It was in the case that of Plessy versus Ferguson, and then third case was that Brown versus Board of Education. They were the case. What? It went on overruling. This is inherent judicial power, that one decision of Supreme Court can be overruled by another decision of the Supreme Court. It is judicial review principle. And it is judicial review in the case that for the first time, Marbury's case, Marbury versus Medicine. Marbury was one of the aspirant of the post of judge of the District of Columbia, that he was appointed by Lambdoc government of Thomas Jefferson, third president, but Adams, third president, second president John Adams, but afterwards the subsequent government president did not confirm the post, and again Marbury filed the case, in that times it said that, but what happened that it is the principle of judicial review that, though it was not clearly mentioned under the constitution, but the latter under the Judicature Act of 1789, what the court there said that any act committed by president, which is the president is the executive of United States, or even Congress, which is the legislative power of the United States, this action can be checked and can be experimented through the judicial review. That is the power of judicial review. And under the Constitution of Nepal, so many cases since the 55-year history of Supreme Court, no, not 55, it is almost 64 years since Supreme Court Act was enacted in 2013, and since 2013, after the very establishment of Supreme Court of Nepal, there are so many cases has been decided by Supreme Court, where Supreme Court has there said that these all are illegal, these laws are illegal, these actions are illegal, even appointment case also, even enactment case also, even dismissal case also. Some government authorities were arbitrarily dismissed, and because nobody can be arbitrarily dismissed, arbitrary action is against the rule of law, and the Supreme Court upheld that these all laws are against this natural justice, because natural justice or fundamental right, one of the purview of the scope of judicial review. And you find under this new constitution 2072, in article 132, it is something talked about judicial review power of judiciary, and it has been mentioned that under article 2 clause 2 of article 132, it was mentioned that the Supreme Court, just you go afterwards 132, you just see 133 article clause 2, it is written that 1 and 2 both are about judicial review. Any citizen of Nepal may file a petition in the Supreme Court to have any law or any part thereof declared void on the ground of inconsistency. What I said that any law, because it is the federal law, it is the state law or local law, which is not inconsistent with the constitution, to make that law invalidate, any man can go to Supreme Court. You can knock. You see the article 133 there, and it is written that inconsistency with the constitution because it imposes an unreasonable restriction on the enjoyment of any fundamental right conferred by this constitution or on any other ground, or to have any law or any part thereof made by a state assembly declared void because it is inconsistent with the made by the, you think it is the new concept under the new constitution. Such concept was not under the constitution of 2063, because under 2063 constitution, Nepal had not entered into the federal government. We are already entered into the federal setup. That's why we have 3 tiers of the laws, 3 tiers of the government and 3 tiers of the law. One is federal law, one is state law and local law. And local law's position is higher than state law is higher than local law, and federal law is higher than state law. There are the 3 tiers hierarchy of the laws. And what it has said that any part thereof made by the state assembly declare void because it is inconsistent with the law made by the federal parliament, or to have any law or any part thereof made by municipal assembly or village assembly declare void because it is inconsistent with law made by the federal parliament or the state assembly. I said that if any local law made by the village assembly or municipal assembly is inconsistent with one higher law, state law, or then highest law, federal law. Not highest law is constitution, but among the 3 law is the highest law is federal law. If these 2 type of law is inconsistent or it contradict with federal law, then it has been one of the it has been one of the scope of judicial review. What it is? It is the scope of judicial review. And the Supreme Court shall have an extraordinary power to declare that law to be void either ab initio or any date of its decision if it appears to be inconsistent. It is very wisely mentioned that these laws would be declared ultra vires or null and void from the ab initio, it is the Latin of ab initio, means from the very starting, very initiative day, these laws, which part of the law is inconsistent with one higher hierarchy of law, then that provision of that law would be declared inconsistent since the very day of its operation, from where it has been operated, and if ab initio it shall be declared null and void. And next is that under second 2, article second 2, just sub article 2 or clause 2 you can study, the Supreme Court shall, for the enforcement of fundamental right conferred by this constitution or any other legal right for which no remedy has been provided, or which the remedy, even though provided, appears to be inadequate or effective, or for settlement of any constitutional or legal question involving any dispute of public interest or any concern, have been extraordinary power to issue necessary and appropriate order, provide appropriate remedies, enforce such right or settle such dispute. Because it is clearly mentioned that Nepane, what it is about, that there shall be the, if there is a dispute of public interest, like what may be the public interest, where if there is a question of environmental degradation, there is the deforestation, or there is a question of child right, about the question of abortion right, female or reproductive health right, and if there is a right about the political and civil rights of the citizens, and if there is the right about the traffic vehicle right, and if there is a traffic is a right about the public nuisance and inconvenience. So many questions can be raised there, and you can find that these people at large, for the public interest, these rights have been invaded, and Constitution has given for the first time that, as I said, that PIL was for the first time, it was the jurisprudence created by the judge of the Supreme Court. It is the court-made law sometimes, it is, because public interest is a very great interest. This interest, not it is individual interest, it is the interest of the people at large. That's why Supreme Court should have played a very positive role to ensure these rights and to restore these rights and to exercise and to enforce these rights for the weaker section of the people, or underdog people, or someone who are out of the access of the state machinery, or someone who are out of approach to knock the door, that even giving the email or sending the email, or even the cutout picture, if it is scanned cutout picture, if it is sent to the Supreme Court, then it is the intentions of India that, or other country, that court would start hearing the case, and they would start, being very positive and very creative, and it gives the concept of the judicial engineering. Hello, you just find the concept that it is the social or judicial, creative social engineering. It is engineering because it is something engineer makes the building block, in the same way it makes the building blocks of the justice, and it is a social engineering with the concept. And you find that PIL is the Supreme Court through the judicial activism. PIL can be activated through the judicial activism, means judiciaries, which are the judges, which are not only to uphold the status quo of the Supreme Court, the status quo position of the justice. Status quo, if it was the previous year, what? If it is maintained same way by the successive judge, then it is not judicial review. But judicial review is that concept that judge can be very creative, judge can be very active, for what? For the benefit of the, and for the million star people, there is starvation also. There you see there is one Umla starvation was there. People are suffering by starvation, malnutrition, and in that time what it may do? It may relax the traditional locus standi. The main concept is that locus standi, if it is conservative locus standi, then suddenly if you go with the peculiar traditional formality of the court, then certainly people won't get justice. That's why it is what? It is a mechanism to relax the locus standi. Locus standi means you can have stand something to appear, that is locus standi. That's why what I said, that Supreme Courts issue the different type of writs, the writs of habeas corpus, mandamus, certiorari, prohibition, and There are so many other, and mandamus also. These are the what? These are the orders by the court, and it may even stop the government action. You just stop it. It is the prohibition, or whatever it has already done, you just correct it, or you just rectify your previous error. That is the certiorari. Okay, and then prohibition, habeas corpus is you just show the body of the man within the premises of the court that if this detention is illegal, then it would check the legality of the detention. That's why the man just present in the court is the habeas corpus. 1679 in England, it was for the first time it was practiced, and habeas corpus would check the legality of detention. In the so many cases, Nyopane and other very promising goal, you are standing there that protecting the right. Promising means you are very experienced. It's a very positive word, promising. You have promised to be something, the promising, you understood?
Take care.
Yes. Then, unable to approach the court, people have not able to approach the court, That's why this is the traditional, it is beyond the traditional concept of what? But never forget, judicial activism should not exceed or judicial limit of judiciary. Judiciary is the only third branch. It is only to interpret the law in constitution, and it is only to administer the justice. That's why never forget the fact what it is that it may not be unruly, it may not be intoxicated in his power and in the vein of like giving justice. It cannot overreach the limit of others, the boundary of constitution as demarcated by constitution. It may not come about to give effect to the separate work of judiciary and legislature in this judiciary and executive. In this way, what I talk and what I told you that sometimes judiciary should not appear as a judicial misadventurer. It should not be judicial adventurism. Girl, you understand? Judicial adventurism means it is something dussahas. Sahas is good thing, but dussahas may give the different result. You may come back with empty hand if you misadventure. That's why if it is more misadventure or adventure, then no positive result would come out. That's why in mostly the American court also has positive, and just like you see there is the in the case of America, so many Stanford versus Wade versus Stanford, and Lawlessness versus New York. Some of the very powerful judicial engineering was propounded by American justice judiciary, and in the same time that may be the what. There is the right of the environment, as I said. These are different right of people. It doesn't come. It is the great concept of jurisprudence which is developing in its own way. Mechanism for justice. Law is proposed and empowered by judge. That's why judicial activism. The law which comes out of judicial activism, it is also equally or judicially equally recognized by the government of Nepal. By constitution you recognize that, and it is the same article you can find in the book that in the course of administration of justice, the law propounded by or precedent propounded by Supreme Court judge or Supreme Court, its status shall be equal to what? It should be equal to other law, parliamentary or statutory law. But once the thing is that statutory law or parliament can overrule this statutory law, or as a directive of the court, next time like this legislature may enact such law in line with the judicial pronouncement. Thus, as I said, these three branches of the government should have the balancing and checking power